SJC-13196, FBT Everett Realty, LLC, the Massachusetts Gaming Commission.
Okay, Attorney Weld. You're on mute.
My apologies, not a good start. May it please the court, my name is Christopher Weld. I represent FBT Everett Realty, LLC, who is the plaintiff and the appellant. There are two primary issues, core issues, I would call them, presented to the court by this appeal. The first one relates to a regulatory taking and whether any one of the three Penn Central factors is an essential element of making out a takings claim, or whether you must read all those three factors as well as other circumstances into the entire analysis.
Okay, Attorney Weld. Hold on one second. Let's see if we can. You're on mute.
I'm not.
Hold on 1 second. There's a problem with feedback.
The issue is that there is a Suffolk feed that's live in someone's office right now. So they need to mute the Suffolk feed. Mr. Weld, if you have that on right now, just turn that off.
Who is the plaintiff and the appellant. There are two primary issues, core issues, I would call them, presented to the court by this appeal. The first one relates to a regulatory taking. And whether
do you have the Suffolk feed on right now?
I don't think so. Let me find out. Element of making out a takings claim, or whether I apologize. Apparently, I did.
Okay, no problem.
Again, not a good start. I think I've lost a minute or so of time. But
well, no, just joking. Go ahead. Just go ahead.
Okay.
Well, why don't we just get into it and tell us why Justice O'Connor's concurrence in Colazzo and the very, very, very narrow exception in Hodel versus Irving helps you as it relates to whether reasonable investment-backed expectation is dispositive.
Your Honor, I think the fundamental distinction here is whether reasonable investment-backed expectations can be dispositive, can overweigh the other two items or elements, but what the court below held is that as a matter of law, not fact, as a matter of law, if you don't present evidence on one of the three elements, you do not have a regulatory takings claim. And I would submit to the court that even beginning with Monsanto, that is not the holding of the court. Monsanto court repeatedly said this is an ad hoc factual determination. It also said that the Penn Central factors, quote, should be taken into account, close quote.
But they also said that a reasonable investment-backed expectation might be so overwhelming that it's dispositive of the issue. And quite honestly, this circumstance is not a situation where Native Americans are not able to leave their land to their heirs.
I agree with you, Your Honor, that they can overweigh or outweigh the other factors. But what Hodel tells us is that even with no investment-backed expectations, the nature of the governmental action and the economic impact can, in fact, outweigh the other factor. The court below did not even consider the nature of the governmental action and did not even consider the economic impact as factual elements to be weighed against the investment-backed expectations. And in this case,
why don't we take them then on the first one on your client's economic impact? The profit margin from the initial purchase to the sale for $35 million was in the hundreds of percentile of profit.
Your Honor, that goes to the element of economic impact, which there was no evidence of in the court below, other than what you've just said. But we did not have any opportunity to discover.
Well, isn't that number precise? I mean, in your favor, we know exactly what the negative economic impact is because we know what your original deal was and what it was reduced. So we do know that number, right?
Right.
So and this is summary judgment, right? So we don't really care about the judge's analysis as long as we have disputed facts established or undisputed facts established, right?
I disagree with that, Your Honor, because the basis of the court's holding, the basis of the motion was we don't have to address the other two factors at all. And the premise of the motion,
No, and I
was-
understand that, Mr. Weldon. I actually am sympathetic to your point, because I look at these cases and it does seem like you're supposed to, including our cases, the cases by Justice Corey, the case by Justice Cowan, we sort of look at all three factors each time. And Palo Alto tells us that even when there's no reasonable expectation, it looks like investment expectation, certain types of extraordinary takings can still qualify. So I get it, but I'm just trying to get a sense of, we know the number of your loss. That's an I mean, I don't think there's any dispute about it, whether the judge weighed it. I understand. You're saying we have to have the benefit of the judge's weighing of these things? Is that, we don't do that ourselves?
I don't believe you do, Your Honor. And the reason is because we have not had a chance to develop a full record. If you look at virtually all these cases, when they hit the appellate court or they hit the Supreme Court, there has been a full trial on the merits, and therefore there's a full record. Here, the nature of the governmental action is the critical element from the plaintiff's point of view.
But don't we have, when we're talking about disputed facts, putting aside that we know the $40 million issue, isn't it an issue of law as to whether we evaluate the economic impact based on the time of purchase, or as you would suggest, later on in the process as wind becomes a serious applicant? Isn't that an issue of law? Whatever your position is, Mr. Weld, whatever it is, isn't that an issue of the law?
The question of when the court is considering the factual elements of weighing the three Penn Central factors, that they have to include evidence about all of those factors. And there, I would agree with you that it's a question of law as to when one assesses the investment-backed expectations on a given facts of the case. Virtually all the cases cited by the defendant involve pre-existing regulations that were there when a landholder purchased the land. So it's an entirely different factual situation. Here, the chronology is important. FBT purchased the property in 2009. The Gaming Act passes in November 2011.
So in 2009, the pre-existing regulation was no gaming in Massachusetts, right?
That's correct.
Okay.
And our argument isn't that we had investment-backed expectations for a highest and best use sale as a casino use in 2009.
And so are there any cases that you have found where this free market value diminution is the investment-backed expectation that you're suggesting your client might have?
I don't think there are any cases anywhere close to the factual. The problem is with the temporal line here. So 2011 is gaming. Early 2000.
I know, but I want to stick with my question, which is in 2009, the pre-existing regulatory scheme did not allow gaming in Massachusetts. And so you're saying this case is different in kind because in Monsanto, the pre-existing regulation said, hey, if you disclose the data, we're going to use it to measure competitive bids and disclose it. And I'm wondering why that's different than this case. Why we don't measure it at the time of the action. Here, your purchase of property in Monsanto, it was the time which Monsanto decided to disclose its data.
For two reasons, Your Honor. First of all, the owner of property has a right to sell the property for the highest and best lawful use. The highest and best lawful use, the value of that was enhanced by the passage of the Gaming Act. But that landowner still has that same right. And the highest and best lawful use, as in November 2011, was for a casino. At that point—
Doesn't that prove way too much? You're basically going to wipe out regulatory taking law if you have the right to the highest and best use of your property, and any subsequent regulations gonna, well, it just seems like I think Justice Wendland's point is there are no cases that ever do that because you basically, it's inconsistent with regulatory taking law.
I disagree, Your Honor. I do agree with you that the government has a right to enact prospective regulatory actions without affecting a taking. And if that action is within constitutional boundaries, then the landowner is bound by it, and it falls into the cases that are land use cases, rent control cases, et cetera. But here, the critical element is that you have a regulatory action, a reduction in the purchase price, targeted to one citizen of the Commonwealth, one FBT. The regulation is not regulatory because, in fact, a casino was built on this property. It didn't say you couldn't.
I get that point, and I understand you may have a strong argument on that third prong, that the character of this action is unique, and we're going to need to probe Ms. Allison on what the justification of that is. But I still have some trouble with you gambling. You're relying on the fact that you get a gambling premium and you have a right to that. But gambling is heavily regulated. And when you bought the property, the gambling was illegal in Massachusetts. So you've got an uphill climb that you have a reasonable investment based expectation in this sort of gambling premium, don't you? That's a real.
Let me give you a hypothetical. So I buy land and it's zoned agricultural. The zoning changes and it's now residential. I then invest millions of dollars into infrastructure. I put in a road, I put in utilities, et cetera. The whatever the regulatory body turns around and says, you know what? I am going to change the zoning just for your property. Nobody else subject to that zoning area, but just for your property. And all of a sudden, I'm telling you, it's now only used for agricultural, and all of your infrastructure that you built is gone. All of your plans to build 25 tract houses is gone. And I would suggest that that type of taking would be a compensatory taking, illegal.
Well, why wouldn't that type of taking satisfy the character of the government action prong rather than be dispositive?
It would satisfy the character.
I'm giving you that. I'm giving
Yes.
you that.
So, but here, I would suggest, and I really think this is an analysis that should be done at the trial court with a full record, but even on the record we have, that the governmental action is so overwhelming in this case as to carry the day. It's much closer to the Hodel situation, the Indian rights situation, than it is to any other of these takings cases, which are much different. They involve regulatory takings that involve large groups of people that are making a sacrifice for the benefit of the whole. And there's no question that that can be done. But here, the targeting in the punitive action, this was not a regulatory action, it was a punitive action. And if you look at Exhibit C to the complaint.
Do we have enough factual, and there I have a question for you, Mr. Well, because I get it. This is very unusual that you would basically direct a lowering of price for a parcel like this. I get by government, but are there any unclear facts here? I'm just trying to get a sense of, so from what I understand, a commissioner directed them to not pay, directed Wynn not to pay more than, the non-casino premium for this property. Is there, and he did so, or the commission did so because it was concerned that a felon of some sort had an investment interest in that property, an organized crime figure. I don't know exactly what the concern was. Are there disputed facts on this? Because again, we have a summary judgment decision here. Normally, we do that kind of analysis.
Well, you will see in the record, the statement of undisputed facts, that the other two prongs are not subject of the facts put before the court, because the premise, the entire premise of the motion was that you don't have to look at those other two factors. We do know some facts, but for example, we believe that the depositions of the
Also,
commissioner.
I'm sorry to interrupt you. Your point is that on summary judgment, the other side did not argue the other two prongs. And so as an appellate court, we're confined to the arguments made, that the issue du jour is only whether or not this one prong is dispositive. And if it's not dispositive, we don't get to de novo review the other two prongs because they didn't argue it. They waived it basically.
It's both that they didn't argue it and that there's an insufficient record on the other two prongs. There is some evidence, but it's insufficient. So for example, we maintain that the sole basis of the action by the commission was to punish, was to fine. Even in the Exhibit C to the amended complaint, you'll see that the IEB uses the term, should we reveal the fine, the $40 million. And this is a shift of private wealth between two private parties by a public entity. I'm aware of no case close.
Mr. Weld, I apologize, but you're only halfway through your argument. You're 1 minute over here. So I'm going to throw a lot into one question. Under the Mass Torts Claims Act, you want to overrule Cogman. We've got Lafayette saying tie goes to the Mass Torts Claims Act every time. We've got Massport clearly distinguishable as an entity. You want to overrule Cogman. There's a lot going on here for you to succeed on the intentional tort not being covered by the Mass Torts Claims Act based on existing law. Why is it that you think we should pivot and change our law here?
I think there are two primary reasons, Your Honor. First, there is language in the statute, Chapter 258, Section 1, in the definition of public employer that says that an independent body politic and corporate is exempt, is not covered by Chapter 258. And effectively what Lafayette does is it writes those words out of the statute, because virtually every public-private entity with mixed elements is going to have factors on both sides of the Cogman test. And if the default is, if there's any unclarity at all, it defaults to you're within the statute. You've effectively written out that language out of the statute. Secondly, and I think more importantly, is the underlying reason for immunity in Chapter 258, and it goes back to the Morash decisions and Cormier when the court was ready to abolish immunity, and the legislature steps in. But the two underlying policies for the statute are, one, to balance between the right of private citizens to get redress for harms caused by public entities. The second is to balance that with protecting the public fisc against, quote, catastrophic impacts. So
what do you do? Well, but what do you do with the, so not only do we have to have a shift here in the law, but we also have some tough legislative history, because there was a bill absolutely considering what you're asking for and having the commission be subject to sue, and that iteration didn't pass.
So let me take, I think there's two parts to your question. The first one is the legislative history. And as everyone knows, there essentially is no legislative history in Massachusetts. It's a guesswork. The prior bill was months before the final bill was passed. There was no conference committee of the prior bill that had the language that you mentioned, Justice Lowy. And in the final bill, that bill contained certain things that came out of the final bill that would suggest independence. For example, the state auditor would serve as a commissioner. The final bill, that was excluded. The commissioner of revenue would collect all of the licenses and fees. Under the final bill, that was excluded. The MGC, the commission itself, now collects the taxes. And so that, and there is no conference committee report to give us any guidance as to why some things were taken out and others were put in, basically weighing on the same factor in a conflicting manner. So I suggest that that legislative history is not as constructive, but what it is, I think, important here is that you have a situation where the legislature set up the Gaming Commission to act as a financially independent entity. The
Well,
gaming
it's not a financially independent entity the way Massport is, which generates, hundreds of millions of dollars and operates and charges fees. It pays for itself, right? But it's not an independent sort of entity creating, financial wealth out there. It's paying its operating costs through certain fees, right? Is it?
It has two components. There's sections 56 and 57 of chapter 23K addresses how you fund the operations of the commission. And the way you fund the operations of the commission is the commission has taxing authority as to the licensees. And whatever the necessary operating budget is for the commission, the licensees pay for it.
And
And there's another
what is that number? I'm just trying to get a rough sense of what that number is, because I remember 20 years ago, Massport would have $500 million or something to that effect.
But my recollection, I'm sorry, I interrupted.
Yep. What is the number for the commission here? What number are we talking about that they generate for themselves?
My recollection, and I couldn't cite to the record appendix right this minute, but I believe it's in the vicinity of $25 million. And so they run their own operation. They also produce revenue that goes and funds public entity, public good, if you will. And the statute has a structure where there are dedicated funds generated from revenue from gaming that go to social causes designated by the legislature. But the core of the operation of the commission itself, which is what's the commission is being sued here, is funded by private parties, private money, casino operators. So that money goes into a fund. If there's too much money at the end of the year, the commission can either retain it or they can credit it back to the licensees. It does not go back to the general fund. It does not go to the Commonwealth. So here, if there were a judgment against the commission, it would arise out of the operations of the Gaming Commission, because after all, this is part of the Gaming Commission's purpose, is to vet licensees. Therefore, that judgment would be part of the operations of the Gaming Commission, and they would tax the licensees for the value necessary to pay the judgment. It's it's designed to be self-sufficient with regards to the operations of the entity itself. And therefore, in this case, there is no risk to the public fisc. So in our going back to our policy balancing of a citizen's right to sue the government for harm against the protection of the public fisc, if you have no risk to the public fisc, where the balancing test weighs in favor of giving the right to have redress against the entity, and therefore Chapter 258 shouldn't apply. The rationale for the statute does not even come into question.
Well, a $40 million judgment is going to ultimately impact how much state agencies and ultimately the general fund does receive. I mean, these commissioners are there's a cost to running this, and there's a point in time where it impacts the general fund, and $40 million is a lot of money.
No, I disagree with you, Your Honor. If you look at Chapter 23K, sections 56 and 57, that if the funding of the operations of the commission are entirely private, they do not involve the general fund. If there were $150 million judgment, the assessment would go against the licensees. It's not an indemnity like the Regent's case cited. It is a tax that the commission can assess on the licensees, and the licensees will foot the bill. And if you look at the Encore Casino, it's a $3 billion operation. They are well able to fund whatever that judgment is, and that's the way the statute is set up. There is no threat to the public fisc from a private judgment against the Gaming Commission because it will be funded by the casino operators.
Okay, any other questions? Okay, thank you. Attorney Allison.
Ms. Allison, would you mind responding to that last point? I'm sorry to throw you off your outline. If there's a $40 million judgment, does that have no impact on other state agencies or the general fund?
No, Your Honor, not necessarily. It might. So the provision which Mr. Weld refers to, which provides that costs of overseeing, the Gaming Act and regulations and the cost associated with that can be assessed to the licensees. If not assessed to the licensees, or if such costs are unable to be recovered, then such costs are appropriated under Section 57. So while the commission has made the point that it's arguable and it would take the position that such a judgment could be assessed against the licensees as a cost under the Gaming Control Fund, the Gaming Control Fund explicitly provides that another source of funds to cover such costs is appropriation. So in that respect, it's entirely different from the Oberg case that FBT has cited to, and much more like the Regents case that the commission has cited to. It's really the liability is with the commission, and at the end of the day, the taxpayers could hold the bag.
On your licensing scheme, can you assess them for an intentional tort that you committed? You have the power to assess for intention. If there's a verdict against you for an intentional tort, intentional, contractual interference, can you assess that as a fee?
The Gaming Control Fund refers to assessments for costs or expenses. If the commission were, subject to a judgment in this case, it would take the position that that could be assessed as a cost and expense to all of the licensees to be shared equally. The licensees, certainly the licensees other than Wynn, might object to that. We would argue that they wouldn't have standing to under the Gaming Act. But that's certainly the position the commission would take. But if such a judgment could not be assessed as a cost, an operational cost of the commission, the Gaming Control Fund explicitly provides that such amounts can be appropriated.
Has the commission ever paid out any verdicts? Because usually you need to pass legislation to pay for a Commonwealth verdict. Has that happened where?
As far as I'm aware, Your Honor, no, the commission has not paid out a verdict or had to, reach a determination as to this question under the Gaming Control Fund.
Ms. Allison, no, go ahead, please, Justice Kafka.
I wanted to switch to the sort of the main event if we could. So if we don't agree with the idea that the investment-based expectation is dispositive, is this a reversal, or do we have to? Is there any way that's not a reversal?
So the commission has taken has argued, and I would, I'd like to expand on that the failure of proof on reasonable investment-backed expectations is dispositive, that's the clear ruling under Monsanto and the federal cases that follow Monsanto. And in fact, given that, the question under a regulatory taking is, has the regulation gone too far? The fact that a plaintiff utterly fails to show any interference with investment-backed expectations necessarily establishes that.
I have a little problem with that because not just Hodel, but Palazzolo or whatever, I'm probably mispronouncing it, basically says, even if there's no reasonable expectation, meaning they bought after the regulation was in effect, you know, they still said that if the regulation goes too far, you can, you know, there's certain things that are beyond the pale, essentially. And then almost every SJC case always interconnects the factors when it's talking about them and uses this too far language. Justice Cowan uses it at one point, and Justice Cordy talks about them as interlocking factors in the case. So I'm a little concerned that we've always looked at all three, and so do the feds now. But go ahead.
So let me start with Palazzolo.
Mhm.
The Palazzolo concurrence does not overrule Monsanto. It doesn't even refer to Monsanto, and it does not alter the effect of Monsanto. What the Palazzolo concurrence does is make the point that in the factual scenario that you just described, Justice Kafker, that you know, these categorical rules that were proposed in that case cannot replace the Penn Central analysis. But Monsanto did not impose a categorical rule.
When you're talking about the concurrence, are you talking about Justice Kennedy's decision, the opinion of the court? Because I'm relying on Justice Kennedy, not on Justice O'Connor. He wrote the majority decision, right?
Right, and I'm referring to the FBT's argument that I think looking to Justice O'Connor's concurrence, which becomes.
I don't even need Justice O'Connor's concurrence. I'm looking right at what Justice Kennedy writes for the majority. You know, he has this sentence about Hobbesian sticks and Lockean whatever, and then he goes, even if you bought after the regulation, that's not a get out of jail free. If the government sort of does something too much, you're still out of luck.
Well, what he's saying there is that you cannot impose a categorical rule to decide if investment-backed expectations were met in the takings analysis. But that's not what Monsanto does. Monsanto does not impose a categorical rule. Monsanto speaks to an evidentiary failure. Monsanto says, it's not imposing any categorical rule. It's looking at the evidence available on reasonable investment-backed expectations.
I get Monsanto is distinguishable on the facts. I get that. But can I ask you another question, which is, the US Supreme Court has not adopted your timing point directly, right? I understand the Federal Circuit has said, we look at reasonable expectations at the moment of purchase. But the US Supreme Court has not been that definitive, have they? And let me give you a hypothetical that concerns me. It's something similar with Mr. Weld. So I buy this property, and then there's a change in regulation after I buy the property, just what he says, and then that allows me to build houses. I build a subdivision with roads and other things. So I've made subsequent investment-based investments based on a change in regulation after the purchase. And then there's another change in regulation. Don't we consider the investments you made after the first change prior to the second one?
No, Your Honor, and let me explain why. So first, with respect to your question about Supreme Court precedent, the cases across the board, you could see from the facts, they're looking to the regulatory regime, the regulatory status at the time, of purchase in these cases. And I think, though this isn't a Supreme Court case, the Ninth Circuit in the Bridge-Inalea case made that standard or that principle really clear when it said that what's relevant and important under all of these cases, citing to Supreme Court precedent, is the regulatory environment at the time of the acquisition, not when the regulation is challenged. And the reason that's important, and it makes perfect sense as to reasonable investment-backed expectations, is that a regulatory taking claim must be premised upon the interest taken in the property as a whole. This comes back to the fundamental problem with FBT's argument. As the commission argued below and the Supreme Court found, FBT can't base a taking claim on a loss of a particular development right of a parcel. And the scenario you just described, that's precisely what it allows it to do. This is why you have to measure reasonable investment-backed expectations from the time of the acquisition. And in fact, and this is what FBT's sort of fair market value argument, this is why it's so fundamentally flawed too. They argue that fair market value essentially equates to investment-backed expectation.
I don't buy into that, but I still don't see why, if again, you bought some property 50 years ago when there's a regulatory change, and then you make all these huge investments based on that regulatory change, and then there's a subsequent one, that's irrelevant. You're stuck, even though the government's changed its mind twice. I mean, I'm confused. I understand why you may have a diminished expectation, but you still got some expectation, don't you? You've invested money based on what the government was doing.
I think you can look to the Penn Central test itself, the Penn Central case itself, to see how strongly it applies this principle. There it rejected a regulatory taking claim based on the alleged, restriction on some particular use or some particular development right. And it said, no, you look to the property as a whole. You don't get to carve up your distinct development rights and say, I've lost all of one development right, so it's a regulatory taking. That is fundamentally inconsistent with what a regulatory taking is. You look at, the property as a whole. And so this is why the requirement that you look to the time of the acquisition makes sense. It's the only way to reconcile what Penn Central is trying to establish as a regulatory taking.
Can I ask one last question?
Go ahead, Justice Gaffney.
So can you talk to me about the conduct? Because my reading of the US Supreme Court says that certain kinds of governmental behavior is beyond the pale. And this is very unusual. This is a targeted at one entity. Tell me, how do we justify this? Tell me what the logic is of this, because I have real trouble following it.
Well, so first, you don't even need to look to the character of the action. We touched on Monsanto, but Monsanto remains good law.
Help me out though.
Assume you do. Just assume you do for the purposes. Just assume you do for the purpose of the question and why this isn't Hodel versus Irving. They're taking $40 million out of the pocket based on a jailhouse call of one individual who may or who may not have an ownership interest in the property. So, assuming that it's not dispositive.
So this case is entirely different from Hodel. Hodel was, courts and commentators across the board say that was a very unique case with respect to the taking, an extraordinarily unusual taking of the rights to pass on property to your heirs. And, the Superior Court below noted the same thing. It's sort of equivalent to the line of cases which say if there's a physical invasion of your property, right, it's necessarily a categorical, necessarily a regulatory taking. It's sort of so unusual that it's on that level, right? This is not Hodel. This is not those special circumstances.
Well, but what is this? Because again, I don't get this yet. I understand the Gambling Commission wants to keep organized crime out of gambling. I get it. But all this does is reduce the amount of money the owners of this get. I mean, if there actually is an organized crime figure in this, the person's still getting money, they're just getting less. I just don't understand exactly what is this what is going on here that we should give it some deference.
So
let me start with
piggyback on Justice Kafker's question. In all of these cases, there is actually a regulation. Congress has passed something. What is what is the regulation here? It seems like there was an ask by the Gaming Commission to take out the casino premium, but there's, for this particular
Well, so the regulatory,
targeted consideration, not like a regulation in the ordinary context of a regulatory taking.
well,
just-
the way, yeah, so the way that FBT describes, the regulatory action is the, commission's acceptance or the, decision to reduce the purchase price. Now, again, I don't think the court needs to turn to any of these facts, but the facts are that FBT and Wynn agreed to reduce the purchase price by amending their option agreement based on the fact that Wynn had expressed concerns about its suitability with FBT, involved in the case. And the commission, expressed that it, had concerns about the transparency of the transaction, giving its paramount obligation to ensure the integrity and the transparency of the Gaming Act. So again, but that the court does not need to turn to, the facts as to the action or the facts as to, the decision, the commission's acceptance of this amended option agreement.
What do we do with the fact that the commission was wrong, or could very well was wrong, given the federal criminal case?
Well, I mean, I don't.
This light body Buffalino thing was jailhouse banter or whatever. They're acquitted of it, and now clearly the commission squeezed the parties, I think, to be polite. So no harm, no foul.
Well, the fact that they were, found to, they weren't, you're right, they were indicted and they were found to be not guilty, but the fact that there, was reasonable doubt is not, equivalent to the commission's reasonable doubt in the criminal matter is not equivalent to the, commission's concerns about ensuring the integrity of the Gaming Act. I mean, those two things can't be equated. So the commission's concerns, which were never resolved, had to do with.
How does this regulatory action, if it is a regulatory action, protect the integrity of the commission of the act? Explain to me how it does that.
So the commission's concerns about whether it was given the full facts with respect to ownership in FBT, whether it was provided false information when it began asking about that, led to the, raised concerns for the commission that there was no there would not be transparency in the licensing process if these issues were not resolved.
How does reaching into the plaintiff's pocket for $40 million provide enhanced integrity? And
so again, I mean, this is respectfully, this was not sort of squeezing anyone. This was the commission accepting a revised option agreement between Wynn and FBT because Wynn was aware.
I thought the commission told Wynn, we may not accept your proposal if you include the FBT, who has a potential organized crime figure or something involved in it. But then it added this qualifier, unless you only pay FBT big box amounts as opposed to big casino amounts.
No, those are allegations, but those are not, those facts are not undisputed. Those facts are not.
But that leads us then back to my original question is, if we have to get into any of this, you lose summary judgment. Because if we do, we've got disputed facts on the nature of the regulatory behavior here.
Those facts are not in the record. And that's why I would like to return to, the argument we've made, which is the court does not have to get into those facts to decide this motion for summary judgment. Monsanto does hold that a complete failure of proof on investment-backed expectations is dispositive. And there are many cases after Monsanto that hold that. And to Mr. Weld's argument these cases do not consider the other factors. I would point you to Monsanto itself, but to begin.
But there's, in Monsanto, it's a environmental, it's a disclosure of permit, of environmental information, right?
It's a
There's no-
disclosure of what
There's
Monsanto
no,
argued was
there's
trade
no
secret.
suggestion of anything, in Justice Gaziano's word, squeezing or any sort of odd, regulatory conduct that could go too far, right? The regulation there is a perfectly normal, standard type of regulation. In every one of these cases, except for Hodel and we're just dealing with a different animal here, aren't
Well,
we?
the point is, as to Monsanto and all of the subsequent cases, is that it doesn't even look at any of those other factors. That's the very point that Monsanto holds
But
you
it
don't
doesn't
have to.
have, it doesn't have to, because we're not dealing with something that may be too far, in the words of the Supreme Court, or, like Palo Alto, what Justice Kennedy talks about. There could be some kind of governmental action that really, even when you don't have an expectation, can be just too much and intolerable.
Well, and so that's not what any of these, none of the cases, Monsanto and post-Monsanto, including the Hathi and Cablevision and Good and the ones we've cited, even suggest that they should be looking to these other factors if there's a failure, regardless of what they are, if there's a failure of proof on reasonable investment-backed expectations. And I would also like—
I see your point that, this gambling premium was really a reach, and these guys made a lot of money on this. So it just doesn't seem like a classic regulatory taking. The problem is the regulatory behavior is just extremely odd. And I just don't know if that can kick you over into problematic territory, even though Mr. Weld's client made a huge amount of money and he was counting on this gambling premium, which, is something he shouldn't be counting on.
our position is it doesn't kick you over, Your Honor, not under Monsanto, and the fact that this case can be easily distinguished from Hodel. But the additional thing that you have to take into account in this case, given the gaming, given that we're talking about gaming, is that the law in the Caesars case, and Abdow, is clear that no one, that FBT, even an applicant, can't have any reasonable expectation that depends on the award of a gaming license. The Caesars case said that there's no, to use the quote from Justice Souter, expectation of value that could support any constitutional property right in a gaming license, that seeking a gaming license is nothing more than hope alone. And if that's the case with respect to an applicant for a gaming license, then it necessarily follows that under the regulatory taking analysis, FBT can have no expectation of value in the award of a gaming license, because we're talking about the gaming context. The commission's discretion here is virtually plenary. That's what the court says.
There are no rules in gaming. I mean, there's got to be some standards of behavior that even in gambling is intolerable, right?
Well, in the Caesars case, with a point that Justice Souter makes is that the gaming commission's discretion is virtually plenary. So to the extent that it's exercising its discretion to determine how it needs to meet its obligations under the Gaming Act, what Caesars found is when an applicant has no expectation of value whatsoever in light of that discretion. And the same analysis would apply here.
But the reality is there were two applicants in play. One municipality had already voted approval. Wynn was on a much greater scale of ability. I don't know about, no expectation in the facts of this case.
That's right, Your Honor. I think that's precisely how you would have to apply, Caesars. And to this case, which is that
Caesars
there can be no
Caesars is-
expectation.
Caesars is a Ninth Circuit case, is that right? I can't remember. what
Caesars is a
Caesars-
First Circuit case, Your Honor.
Caesars is a First Circuit.
Yes. And that's precisely what it says, that, you know, there can be no expectation of value tied to the potential award of a gaming license. And this was with respect to an applicant when, and the same would hold here. There can be no expectation of value sufficient to support a reasonable investment-backed expectation as to FBT.